My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian Constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
Welcome to Module 4 of Course 10, and we are still looking at the rights of persons under detention and prevention of torture. In this particular module, we shall be looking at the prohibition of torture and ill treatment. This is really a very important course, and I want you to pay very close attention because we have this issue occurring in most cases. There is a lot of complaint bordering on torture and ill treatment of detainees, and this is why this course is really very important. Now, the objective of this lesson is to create awareness regarding the prohibition of torture. It's important you understand that torture is prohibited by law. It is not allowed. And under other cruel, inhuman, and degrading treatment or punishment, as well as the strategies for its prevention. So this is why we are taking this course, to create awareness for you to understand that it is wrong for you to torture somebody who is in detention. End of this training, it is expected that police officers will be able to increase their knowledge on the prohibition of torture and other cruel, inhuman, and degrading treatment or punishment, as well as strategies for its prevention. As a way of introduction, we'll try to define what torture and cruel and inhuman treatment is. And torture and other cruel, inhuman, and degrading treatment or punishment violates human rights. When we talk about torture, we're talking about ill treatment. When you punish someone beyond, when you put somebody under torture, under severe pain, or cruel or dehumanizing condition, it violates human dignity. Remember what we said in our previous modules, that the right to human dignity is a fundamental human right. Not just only for citizens, but also for you. The same way you want to be treated with dignity as a human being is the same way you should treat people in detention with dignity, and are absolutely prohibited. It means that torture are absolutely prohibited at all times and under all circumstances. Police officers can never justify committing one crime in order to solve another. Listen, it is important for you to understand that because somebody committed a crime, committing a crime by torturing the person doesn't make that crime go away. So you don't have to commit a crime, which torturing people under detention is, simply because somebody committed an offense or committed a crime. And there are various declarations, human rights declarations, treaties that Nigeria is a signatory to that lists the prohibition of torture in dealing with people in detention. One of them is the Universal Declaration of Human Rights, the UDHR Article 5. Another one is the International Covenant on Civil and People's Rights, the ICCPR Article 7. The African Charter on Human and People's Rights is very explicit on this, and it can be found in Article 5. The Geneva Convention of 1949 also frowns against the use of torture in dealing with people in detention. Additional protocols to the Geneva Convention of 1997. The Rome Statute of the International Criminal Court of 1998, Article 8, also frowns at this. The United Nations Code of Conduct for Law Enforcement Officials, Article 5, explicitly frowns at this. Also, the body of principles for protection of human rights under any form, detention or imprisonment, Principle 6, all of these things frowns against the use of torture. The prohibition of torture forms part of customary international laws, which means that it is binding, regardless of whether a state has ratified the international treaties expressly prohibiting torture. I need to stress this. What it means is that whether a country has domesticated a law saying that it is wrong to torture victims, the international law is binding on you, whether you have ratified or domesticated it or not. So you cannot claim ignorance and say, well, there is no such law in my country. No, it is binding in your country. All law enforcement officials should be informed and educated about the prohibition of torture and ill treatment. Now, we need to define what torture is. Torture is defined as any act by which severe physical or mental pain or suffering is intentionally inflicted on a person other than which is inherent or incidental to lawful sanctions. What it means is that severe physical pain, severe physical discomfort, severe difficult punishment, or even mental pain, which is very important. You can torture somebody mentally also. When you subject somebody to cruel mental torture, it is also a form of torture. It is not just physical torture. We are also talking about mental and emotional torture. Very important. Any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or confession. This is always, this is very rife in most police enforcement agencies. Forcing people to, subjecting people to torture in order to extract some form of confessions from them. You are punishing someone to be able to make the person confess that he committed an offense. It is prohibited by law. So when you force somebody to confess to a crime, whether the person committed the crime or not, you are not supposed to use torture to obtain those kind of information. It is against international law and it is against the human rights of the person. So when such pain or suffering is inflicted by or at the instigation or with the consent or acquiescence of a public official or other persons acting in an official capacity, we can say the person is committing what? Torture. It does not include pain or suffering arising only from or inherent in incidental to lawful sanction. It means that probably maybe you sanction somebody to do something by law. That is not part of torture. In defining torture also, we need to look at the Section 2 of the Anti-Torture Act of 2017 for acts constituting torture. It's very important that you look at that act to understand, because it is listed there, the acts that constitute torture, so that when you are subjecting somebody to degrading treatment, you know that you are committing a crime and you can be charged on the basis of your actions. Go further to define ill treatment. And we say that ill treatment is any act of cruel, inhuman, or degrading treatment or punishment which do not amount to torture. Any act of torture committed as part of a widespread or systematic attack directed against civilian population with knowledge of the attack is a crime against humanity. And this is contained in Article 7 of the Rome Statute of the International Criminal Court. And you can be dragged before the International Criminal Court to go and answer for your crime. So it is very important for you to understand it. Each state party shall include this prohibition in the rules of instructions issued in regard to the duties and functions of any such person. If you look at even in your code of conduct, you understand that some of these things we are listing here is included there. And of course, it's included there with the intention to make you understand the importance of ensuring that rights of citizens are upheld, even people who are either in detention or people that are arrested. They don't cease to enjoy their rights also continues to hold true. We go forward to look at the core principles of in these articles, and we're going to look at a number of them. The first one we're going to look at is Article 2 of the UNCAT. It says that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. There is no exceptions to this rule. Very explicit. There is no exception, meaning that no one, regardless of the person's crime, regardless of where the person comes from, regardless of how deeply hurt you feel, should be subjected to cruel, inhuman, or degrading treatment. We look at Principle 22 of the Body of Principles for Protection of All Persons. And this one says that no prisoner or detainee shall be subject, even with his or her consent, to any medical or scientific experimentation which may be detrimental to health. Very important. You are not allowed to subject somebody in detention to any medical experimentation. Even with his consent, it is not allowed. Without the person's consent, it is not allowed. Now, any statement made as a result of torture shall not be invoked as evidence in any proceeding except as evidence to bring the perpetrators to justice. This is contained in Article 15. Very, very important. If you obtain confessional statements on duress or when you under torture, what it means is that if you present it before the law court, it can be discountenanced on the basis that that confession was obtained under duress. We will continue. Law enforcement officials in dealing with persons in custody or detention shall not use force. Shall not use force except in very limited circumstances, including in, look at the exceptions, only when you can use force, only in these conditions, self-defense and the defense of others against an immediate or serious threat. You are only expected, or you are only allowed to use force for people in custody only when you want to defend yourself or when you want to defend other people from serious harm. Okay? Now, further Rule 33 of the Standard Minimum Rules states that the instruments of restraint, such as handcuffs, chains, irons, and straitjackets, shall never be applied as punishment. Handcuffs, chains, iron rods, straitjackets, you are not supposed to use them. Each state party shall keep under systematic review interrogation rules, instruction methods and practices, as well as arrangements for custody and treatment of persons under their jurisdiction. What it means is that every state must have a rule that says this is how people can be interrogated. If you go to even advanced countries, there is a standard rule to say, listen, this is the only protocol you're supposed to follow in treating people when interrogating them. And I believe we also have it here. And that is what we must do. If you're interrogating somebody in your custody, it becomes your responsibility to ensure that you adhere to that rule book. We go forward. Investigation and prosecution of torture. Article 12 of the United Nations C80 states that each state party shall ensure that its competent authorities proceed to a prompt and impartial investigation wherever there is reasonable ground to believe that an act of torture has been committed in any territory under its jurisdiction. What are we trying to say? Under this article, states should initiate investigation when they believe that a police officer or a law enforcement officer has used torture under investigation. The person should be investigated. That allegation should be investigated. This is very important. If someone comes tomorrow to come and probably send a petition against you to the National Human Rights Commission saying, when I was under detention, I was subjected to inhuman or degrading treatment, it means that that allegation can be investigated. In fact, it should be investigated according to Article 12. Article 13 says that each state party shall ensure that any individual who alleges that he has been subjected to torture in any territory under his jurisdiction has the right to complain to and to have his case promptly and impartially examined. That's what we just said earlier on. Article 14 says that each state party shall ensure that in its legal system, that the victim of an act of torture obtains redress and has an enforceable right to fair and adequate compensation. Now, when you hear some court rulings and the court declares the police or the DSS should pay certain amount of money as damages, that's what this Article 14 is trying to say. That when someone is subjected to an inhuman treatment, the person has the right to complain and the person has the right to enforce his right to fair hearing, and the person is also entitled to adequate compensation. Nothing in this article shall affect any right of the victim or other persons to compensation which may exist under national law. What it is trying to say is that nothing in this article should in any way affect the right of any citizen to enjoy compensation, even if it doesn't exist in their national laws. As long as it exists in the international laws and that Nigeria is a signatory to that treaty, every Nigerian is entitled to some form of compensation when he or she is subjected and it is proven that the person was actually subjected to torture. All deaths in custody, incidents of torture, and ill treatment and disappearance of detainees and prisoners shall be promptly investigated. I mean, most times we hear Amnesty International will release their human rights research for a particular year, and you hear that a set of people or some number of persons disappeared in a year, or that this state encourages torture, and you hear things like, Amnesty International is aiding and abetting crime. It is because of issues like this, but it's not supposed to be so. Nigeria is a signatory to some of these international laws, and it is imperative that we obey them. So disappearance of persons under detention is not supposed to be condoned in any manner. Ill treatment and torture of accused persons should not be encouraged in any manner. We go forward. We'll look at the non-admissibility of evidence obtained under torture. And this is what I actually made reference to earlier when I said that when a statement is obtained under torture, it may not be admissible as an evidence before the law court. So the police officer should always ensure that they act in a lawful manner when conducting an investigation and follow the prescribed procedures. Law enforcement officials must refrain from any action that can be interpreted as aiming to extract a statement from an arrested or accused person which can be said to have been given with or without her free will. This is very important, because after you have built up your case and you now go to court and you present an evidence, and when you present an evidence, the judge, the accused person will say, this evidence was obtained under torture or under duress. I didn't give it out of my free will. What do you think will happen? Your evidence runs the risk of being thrown outside the window. So it is important that pressure on the suspect to come him or her to testify can result in an important confession given by the suspect in order to prevent further pressure. What it means is that an accused person can actually accept that he committed an offense just because he doesn't want to be tortured further. And at the end of the day, when you now present the evidence, the person will say, I didn't make this statement out of my free will. It now becomes a problem. Okay, so we also need to monitor the places of detention. That is very important. Where we keep people under detention, how is it? And this is also contained in Article 2 of the United Nations, the UNCAT, which states that each state party shall take effective legislative, administrative, judicial, or other measure to prevent acts of torture in any territory under its jurisdiction. What it means is that Nigeria or countries that are signed onto this agreement should ensure that there is effective legislation, effective administrative, judicial, or in fact, you need to take measures to ensure that acts of torture is not conducted in any territory under your jurisdiction. This is very important. It means that there is no territory in Nigeria or any detention facility you can say in this detention facility torture is allowed. No. In line with the Rule 36 of the Standard Minimum Rules and Principle 33 of the Principles on Detention, detained or imprisoned persons should have the right to make a request or complaint regarding their treatment in the event of death of a detainee. What it means is that when someone is under detention and probably a fellow detainee dies because of the inhuman and degrading condition, the other person has the right to make a complaint regarding the condition which he or she is being kept in. Again, in order to supervise the strict observance of relevant laws and regulations, places of detention shall be visited regularly by qualified and experienced persons external to the prison administration. What it means is that there should be regular visits by independent authorities that are different from state actors to see how those detention centers are, to see if the detention centers meet up to these standards, and to see if indeed there is any torture facility around the Nigerian jurisdiction. And this is really very important. Article 11 of the UNCAT states that each state party shall keep under systematic review interrogation rules, instructions, methods, and practices, as well as arrangements for the custody and treatment of persons subjected to any form of arrest, detention, or imprisonment in any territory under its jurisdiction, with a view to preventing any cases of torture. What it means is that Nigeria needs to, from time to time, submit for interrogation its instructions, rules, methods, and practices that regards to interrogation of people under detention, or that regards to the facilities, or that regards to detention facilities, or the modus operandi that is used in interrogation. All of these things are supposed to be regularly submitted for interrogation to ensure that they meet up to these standards. And that is what Article 11 is trying to say. Now, customary international law already requires states to prevent torture. Also, as stated earlier, the UNCAT also expressly includes a general obligation for each state party to take effective measures to prevent torture and other cruel, inhuman, or degrading treatment. And I know that Nigeria has also done that. These are contained in the following: Article 2, Article 16, then the third paragraph of the preamble of the UNCAT. Now, the UNCAT also created a committee known as the Committee Against Torture, which periodically assesses each state party's progress towards the implementation of the provisions of the UNCAT. Now, there is a committee again. That's to tell you how important the issue of torture is. Now, the United Nations have a committee that is primarily vested with the power to periodically assess each state party's progress towards the implementation of the provisions of the UNCAT. This committee relies primarily on formal written reports submitted by the committee's office in Geneva by government and national non-governmental organization. So what it means is that your duties and responsibilities in the force is often documented and is sent to Geneva, for them to reappraise how Nigeria is obeying some of these principles. Following this, the committee undertakes separated face-to-face discussions in Geneva with state authorities and with NGOs. In addition, some of the state parties have also authorized the committee to consider complaints from individuals to which the committee responds through written decisions In some very rare instances, the committee may visit a territory of a state, but such visit will only occur with the specific consent of the state party as provided under Article 20 of the UNCAT. What it means is that in under rare cases, there could be complaints directly, to the UNCAT, and then they will move to investigate such allegations. To provide a further practical tool to assist states in meeting the obligations they already have under customary international law and the UNCAT, the optional protocol for the United Nations Convention Against Torture, which we call the OPCAT, established a system of regular visits to places of detention by independent experts in order to prevent torture and other forms of ill treatment. What it means is that, the UNCAT have provided a mechanism through which there could be regular visitations to see how these detention facilities are kept, if there are ill treatments and torture. And that is to tell you that the issue of torture is really very important, and we cannot overstress that very important point. Thus, this introduces a system of regular visits to places of detention by independent national and international experts to serve as the basis for practical and constructive dialogue between visiting experts and the authorities at international and national level. Now, I know these things also occur in Nigeria here. When you have some NGOs, some civil society organizations that pay regular visits to our correctional facilities and detention centers to see firsthand how those facilities are, and of course also to find out how inmates in those facilities are treated. The first pillar of the OPCAT's approach is a program of visits carried out by the United Nations Subcommittee on Prevention of Torture. You can see that in Article 2 and Part 2 and Part 3 of the OPCAT. If you look at your manual, some of these things are explained in further details, but we can't go into details to explain that. But when you look at your manual, you will be able to understand some of these things. Interestingly, the subcommittee, unlike the United Nations Committee on Torture, is not required to seek a party's consent to undertake any visit to the state party, as this is already implied with the state party ratification of the OPCAT, which gives a blanket consent for this. I need to explain this part. Now, what this part is trying to say is that if you, as a state party, is signed onto the OPCAT, they don't need your express permission to come and investigate. They don't need your express permission to come and look at your detention facilities, because when you signed it, you gave them a blanket expression to actually come at any time they want to inspect your detention homes, and this is really very important. Of critical significance is the second pillar of the OPCAT's approach, the establishment of the National Preventive Mechanisms, the NPM, in each state party. This is more significant given the fact that the proximity, regular presence, and scope of coverage of the national mechanisms vis-a-vis the international mechanisms. What this is trying to say is that there is also a national mechanism, which makes it even closer. Instead of probably people coming from Geneva first to come and investigate or look at what is happening, there are national preventive mechanisms that, of course, this OPCAT also makes provision for, that makes it easier for investigation carried out in detention facilities. Okay, we are going to look at the definition of place of detention. I want you to pay very close attention to this particular definition, because when we talk about a place of detention, it is clearly defined. The Association for the Prevention of Torture in 2016, in its guide on the establishment and designation of the national preventive mechanisms on torture, listed examples of where you can call a detention facility. You can't detain someone in your house because you're a police officer. Your house is not a detention home. You can't detain somebody in any place of your choice because you're a police officer. That is very wrong, and it goes against this rule. So we are going to list them so that you understand explicitly where is defined as a place of detention. Number one is the police station. You can detain someone in a police station. It is designated as a detention home. Pre-trial centers or remand prisons. This is very important. Of course, people are remanded in correctional facilities. We don't call them prison facilities again. It is called correctional facilities. Prisons for sentenced persons. That's correctional homes for sentenced persons. Juvenile detention centers for children. Border police facilities and transit zones at land crossing, international ports and airports. This means that this is just for a makeshift arrangement where you detain somebody just by the border because you can't take the person to a nearby police station. This is allowed. Immigration and asylum seeker detention centers. Somebody wants to seek an asylum, moving from one country into another country, and there are detention centers for these special classes of people. You can also detain somebody in a psychiatric institution. And if you remember what we said in our last module, the number of hours you are expected or required or excused to detain somebody, 72 hours. That's 3 days in the interim, so that you can assess the person's mental condition. Security or intelligence services facilities. For example, here in Nigeria, the DSS has their own detention facilities. The NIA, I think, also have their own detention facilities. This is also listed as a place of detention. Detention facilities under military jurisdictions. It means inside military barracks, in military detention centers, it is possible for you to keep an accused person there. Places of administrative detention. That is also, in fact, this one has to be explicitly stated that this place is a detention place for administrative purposes. That means this person is kept here, his case has not been fully determined, the person is just here on administrative based arrangement, pending when investigation is finished and the person is now moved out of the place. Means of transport for the transfer of prisoners, you know. This is very important. For example, in police van, you can detain somebody inside your police van, just in transit. Now, the NPM guide further stated that it is not enough that the NPM should be given the right to visit only official places of detention, but should also extend the visit to unofficial places of detention. Unofficial place of detention is any place where a person may be held for reasons connected with public authority, even if no public official actually formally ordered the detention. What this means is this. Now, if you take somebody and detain the person in your house, or detain the person in an unofficial place of detention, not listed among these things we've looked at, it means that the NPM can come there to visit, to see exactly what is happening there, even if it is not listed as one of the official places for detention. Now we're going to look at the types of visits to places of detention. Article 1 of the OPCAT describes key aspects of the form of the NPM visits. Now, number 1 is establishment of a system. Number 2 is regular visits. Number 3 is to be undertaken by independent bodies. Number 4 is that the target location of the visits are where people are deprived of their liberty, where people are deprived of their freedom of movement. For example, the police cells, the prisons, and other places of detention. The purpose of the visit is to prevent acts of torture and other cruel, inhuman, or degrading treatment. This is important. So what we are trying to say here is that these regular visits, you know, is to ensure that there is no inhuman torture or cruel and degrading treatment that is being meted out to detained persons under custody. Now, the NPM guide further explains other types of visits other than preventive visits that independent bodies may carry out in places of detention. Now, we need to look at some other visits that the NPM can, or that, the NPM can also visit outside what we've already looked at. For instance, a reactive visit is triggered only after a specific complaint of a violation is received by a complaints body at its office outside the place of detention. Now, what it means is that when someone, apart from the regular visits that they are supposed to conduct to see how the detention facilities are and how people are being treated, reactive visit is when there is a formal complaint that is received at the office. And when that complaint is received, they now go to verify and investigate the strength or to verify whether those allegations are actually true or not. Reactive visits generally seek primarily to resolve the specific problem of the complainant or to investigate and document cases in order to punish perpetrators. Okay? Now, the NPM guide also explained that there are times when a reactive visit can, as a side effect, also contribute to prevention through increasing transparency and accountability. When somebody goes on a reactive visit, for instance, to go and investigate a particular complaint, the person can now go there and now discover other things that he didn't even come to look at. You understand me? Somebody can just be on a particular visit to investigate a particular allegation. And when the person now goes there, the person now sees there are other degrading and inhuman treatments that are going on in those facilities. The visit also enables the visiting team to establish and maintain a constructive ongoing dialogue with detainees and authorities. When these visits are carried out either by non-governmental organizations, or international non-governmental organizations, or by international state actors to verify the condition of people who are in detention, it helps in promoting dialogue between the detainees and the authorities. When the visiting team goes to those detention facilities and find out some of those inhuman treatments, they can, engage the authorities on how to be able to improve the condition of living of people in detention homes. It also helps to chart progress or deterioration in the conditions of detention and treatment of detainees over time. It helps to chart progress. Maybe people have been complaining, detainees have been complaining for a long period of time, we are being abused, we are not treated well, nobody listens to them. But visits like this also helps to, to speed it up, to compel the authorities to act faster in those kind of complaints. It helps to protect the detainees from abuse through the general deterrent effect of the continuous possibility of an outside scrutiny. Now, when you know that the authorities can visit at any time, it means that even the people in correctional facilities will be very careful of their actions, knowing that they can be caught in the act, or that when the authorities visit, the cases of abuse can be reported to them and they will be sanctioned. So this is really very important. It also helps to protect detainees and staff from reprisals against individuals who have cooperated with the visiting body on previous visits. What it means is that individuals who give out some form of information to visiting bodies, when the visiting body visits again, it prevents the prison authorities or the correctional facility authorities from punishing people who give out information on how they are being treated, because they know that when the visiting authority comes back again, the detainees can also lay more complaints against them and sanctions will most definitely take place. Now, Nigeria has ratified both the UNCAT and the OPCAT. So what we are trying to say is that these things we've been looking at since Nigeria has ratified it. Nigeria is a signatory to these international laws. Nigeria also, following the recommendation of its first universal periodic review in 2009, established the National Committee on Prevention on Torture. Now, it also has the National Human Rights Commission. Remember, we said it before, which was established by the National Human Rights Commission, the NHRC Act of 1995, as amended by the NHRC Act of 2010. So what we are trying to say is that Nigeria has ratified both the UNCAT and the OPCAT, and now went forward to establish the National Human Rights Commission. Now, the NHRC, which was established through an act of 1995, has the sole responsibility of investigating some of these things that we have been lifting, some of these things we've been listing here. Now, Section 5 and Section 6 of the National Human Rights Act, as amended, provides for the function of the powers of the National Human Rights Commission respectfully. We're going to look at some of the powers that have been vested on the NHRC by the Act of 1995. Now, the first one is to monitor and investigate all alleged cases of human rights violation. It is the duty of the National Human Rights Commission to investigate alleged cases of human rights violation. So what it means is that if there is any allegation of human rights violation by citizens that probably a particular detention facility, a lot of torture is going on there, the NHRC has the rights and responsibility to monitor and investigate those allegations. The second function that they also carry out is to assist victims of human rights violation to seek appropriate redress and remedies on their behalf. It's their responsibility. When someone has been mistreated, when someone's right has been violated, they can help the person to seek redress within the ambits of the law. They also receive and investigate complaints concerning violations of human rights and make appropriate determination as may be deemed necessary in each circumstance. What we are saying is that it's their responsibility, according to Section 5, to look at some of those allegations of human rights abuses, to investigate them and ensure that there is appropriate sanctions and redress. Now, the powers of the National Human Rights Commission, continuing, also gives the Commission the power to conduct its investigations and inquiries in such matter as it may deem appropriate. What it means is that the NHRC is independent. When they want to carry out their investigation, it is their in fact, it is at their own discretion to choose any model they want to adopt. They don't need to defer to anyone. They have that sole responsibility. They can conduct their investigation in a manner they think that will enable them to get the adequate facts that will help them to really further their investigation. They also have the powers to institute any civil action on any matter it may deem fit in relation to the exercise of its function under this Act. And I remember we talked about this in an earlier module, saying that the National Human Rights Commission has also the powers to take legal action against state actors when acts of human rights violations are recorded. They can appoint any person, whether or not such is in the public service, to act as an interpreter in any matter brought before it and to translate any into a book, paper, or writing to be produced by them. What this means is that the National Human Rights Commission, they can hire consultants to help them interpret the law, to help them say, okay, this is actually a violation or this is not actually a violation. Also to help them in terms of publishing their Human Rights Watch at the end of the year or as they may deem necessary. They can also cooperate with and consult with other agencies and organizations, governmental and non-governmental, as they may deem appropriate. What it simply means is that the NHRC cannot and do not work in isolation. They need to seek the partnership of other agencies of government, of non-state actors, of non-governmental organizations like PRAWA and like Clean Foundation, other non-governmental organizations that can help them in order to be able to fulfill their mandates. The non-governmental organizations such as the Nigerian Bar Association, the NBA, PRAWA, and other faith-based organizations may apply to visit police cells and prisons and conduct humanitarian or reactive visits. What it means is that NGOs can say, okay, we want to carry out some humanitarian activities in the prison. They can apply to visit police cells or to visit prisons, to even carry out reactive visits. If you remember what we talked about, what we said about reactive visit, that is a visit that is conducted to investigate a complaint or an allegation. If there are allegations of torture or human rights abuses, these organizations can actually apply to visit to verify the veracity of these claims. During the second Universal Periodic Review of Nigeria, held in 2012, PRAWA and the International Rehabilitation Council for Torture Victims, IRCT, with inputs from the network of organizations on police reforms in Nigeria, NOPRIN, advocated assistance of NPMs, given the scope and population of Nigeria, including the strengthening of the National Committee on Torture Prevention and National Human Rights Commission to work in this regards, as well as introduction of an ombudsman and increased access to NGOs to visit all places of detention. This whole story is trying to say that in 2012, when there was a Universal Periodic Review, that PRAWA, in conjunction with IRCT, made recommendation that said that the NGOs should be given greater access to go into the detention facilities to investigate how citizens and detainees are being treated. Now, in conclusion, the importance and sanctity of human life, including that of a person suspected, accused, arrested, or detained, cannot be overemphasized. Sanctity to human life. That whether you are arrested or detained doesn't mean you don't have your right to life. You still have the right to life. Even when an accused person is found guilty, only the court can commit him to appropriate sentence against which he has a right to appeal. So what we are trying to say is that now, when only the court has the right to sentence, even when the court sentences, the punishment that should be meted out to the person should be, the punishment should remain within the ambits of what the judge or what the judgment provided. You must not go beyond that. Every police officer should do everything possible to avoid cruel, inhuman, degrading treatment, punishment, or torture, or extrajudicial killing. Remember that when you are torturing a victim, when you are torturing an accused person or a detainee, the person can die. You can harm the person in a way that the person will not be able to come back to normal. You can even turn the person into you can impair the person physically. And when you impair somebody physically, or when the person dies in detention, you will be called to answer for those crimes. So it is important that we take the issue of torture very seriously. You are not allowed to torture an accused person under detention. Whatever you are doing, ensure that you work by the rules and the code of conduct of the Nigerian police in order to stay on the side of the law. We have come to the end of this particular module. I will see you in our next class. Thank you very much.